let's see here. Do that little number for ye. Alright, how much bigger can we make this so people can fucking see it? Oh, look at that. Look at that. And a little adjustment. If I can lighten the background out. I hate seeing that fucker. Let's see, can we do a little magic here? Do. Damn that light. I can't stand that son of a bitch. Alright, that's as good as I can get it for y'all. Been on a roll the last few days. Rest assured, I'm not doing this for you. I'm doing it for me. It's not a selfless act. It's very selfish. Because I want to see the people of America, and furthermore the people of the world and the people of the Union of States, stand up with a big middle finger in the air and say, we ain't taking this shit no more. That the people are becoming fully availed and cognizant of the rampant corruption and hypothentication of our credit using false and misleading and deceptive trade practices with a false conveyance of language to deceitfully ensnare people into floating bonds and securities to we the people's detriment, to the benefit of these servants and their principal and organization and retirement funds. So for people to say, oh, Derrick's a really good guy for what he's doing, think of me what you will, but I want you to perfectly understand here and now and very clearly that the reason that I'm doing this is very selfish. And I hope that you understand that by utilizing this information, you are responsible when you use this. This isn't for the faint of heart. You will be challenged. Mark my words. You will be challenged when you use this information. They will test you to make sure you know what you're doing, and you better have the grit and the balls to stand up and sound off like you got a fucking pair, or they will bury you. All right? And I'm speaking from fucking experience. Okay? I've had a number of lawyers, attorneys, if you will, tell me what you're doing is noble. It's valiant. But if you continue down the path you're on, they're going to find the deepest, darkest hole they can stick you in, and that's where you're going to be for a long time. They have that kind of power and authority, Derrick. It's not that they have that kind of authority. It's that the general mass is asleep at the wheel, and we don't protect and defend one another because we're not cognizant of the fact that a trespass on your rights is an indirect trespass on mine. And if I allow them to do it to you, they're going to do it to me eventually. And then they're going to do it to your offspring, and so on and so forth. People are very lackadaisical. They're passive-aggressive in most instances. They're afraid of retaliation. All right? And that's one of the tools that's being used to suppress the people throughout the world. This isn't just about the United States of America, ladies and gentlemen. This is international. This is global, if you will. All right? And it's the great Leviathan, if you will, of systems. You know, 1 million ears, 1 million eyes, 1 million arms, and it reaches out and it touches each and every one of you, whether you're cognizant of it or not. A lot of times I run into people who say, Derrick, you know, I'm not in disagreement with what you say. I don't agree with everything you say. A lot of what you say resonates with me. I like the fact that you point out your work. You're showing where you're getting the information from. But what do you expect me to do? All right. And I expect you to pay attention. I expect you to commit to memory and make a commitment to yourself and your family and your friends that you'll try to do better in protecting everybody's rights. Okay. I listened to a podcast the other night after I got done making my video, and it about made me sick because the guy that podcasts he's a pretty brilliant gentleman. He's very articulate. His IQ is definitely up there. And he was saying, you know, that rights is nothing more than a religious belief. And I started laughing. And he said, you know, can you explain rights? You know, it's just a bunch of hyperbole as far as I'm concerned. It's a belief. And he said that there essentially is no such thing as rights. There's just might and force. And so in his life, everything is about conquering and conquest, obviously. Let me explain rights to you real quick in the most generic, basic format. If I have a right, somebody else out there has a duty. Let me say it again. If I have a right, someone else has a duty. All right? And that's how rights can be substantiated. All right? And your servants have a duty to do what? Protect your rights. And you have a right to life, liberty, pursuit of happiness, and the enjoyment of property. Okay? We are kings without subject here in the United States of America, in the Union of States. We are very unique to every other landmass throughout the world. And the powers that be are very envious of that. So envious to the point where they push poisons on us through our food. They push poison on us through vaccination, through indoctrination, because they don't want us to comprehend just how unique and how powerful a small collective group of people are throughout the world. We're 5% of the world's population, if the general consensus is correct. And we're not saying that the census is correct. I'm not saying there are 7 or 9 billion people on the planet. There may very well be more. And what we do know is that we're not running out of food or provisions or land, because the Heavenly Father tells us that there is more than enough, that what He has created is more than abundant and more than plentiful. We're just supposed to be good stewards and caretakers. But it's time for us to assert ourselves, dignified, with clear, concise language, and to comprehend the system that has been created around us. It's in every facet of your life, from the time you lay down to go to bed to the time you wake up in the morning, work all week, take the weekend off, go on vacation. Forever and a day, there is one thing that will forever be surrounding you and be intricately woven in your life throughout your existence on this earth. And that little thing is called the law. And if the law is so important, and everybody is expected to know it, one should ask themselves, how come we're never taught the different jurisdictions and law forms throughout grade school, high school, middle school, and college? So, if you're just joining us now and you haven't formally watched the other videos, before you partake in doing anything that I'm about to share with you this evening, it is imperative, it is very important that you go back and watch the other videos so you can fully grasp and understand this concept here. Okay, law is an applied science, all right? And there are rules to it. Just like there is a law to grammar, there's a law to mathematics. There's an applied science to what I'm about to inform you of this evening. And I will tell you this much. When you master this, you will now hold in your constructive possession the master key to all financial issues in your life. A lot of my mentors frown upon me for sharing this with you guys. They don't want me to share this with you. It's supposed to be on the private. It's not supposed to be in the public. But my problem is there's strength in numbers. And unless people truly can wrap their head around and comprehend about what I'm about to explain to you tonight, a great majority of the good people out there will continue to suffer. And so I would encourage you to share this with your friends and your family, but stress to them how important it is to go watch the other videos. I give this information freely. I do have classes that I do charge for from time to time for people that need me to hold their hand or just want to get together collectively as a good group. And I take the time diligently to apply myself for 140 to 180 hours to put a very powerful PowerPoint presentation together to help people comprehend on a higher level. And I may do that with some of this information in the future. But I give it away freely every day. I also have a YouTube channel, and a plethora of people have written to me privately telling me that because of that YouTube channel, they were able to liberate themselves, their friends, their family, and help people in the communities that they're in. You're not going to change Washington, D.C., ladies and gentlemen, but we can change this nation to something that was once great and abundant, which seemed to be common sense, okay? And we can do that within our communities, and we can change these communities, and we can right the wrongs. The pendulum has swung way too far to the left, and it's time for a correction to happen. And that correction, ladies and gentlemen, is you and I. We have to look in the mirror and realize we're the problem. But the best part about recognizing we're the fucking problem is now there's a fucking solution. All right? You can't make anybody else do anything, but when you realize you're the problem, you can make yourself take corrective measures and actions that will alter the future. Be the change you wish to see. Lead by example. So, if you've been with me for the last few nights, we've been through the 73rd Congress, first session, volume 77, part 1. I went through about 44 slides of my 345 slide presentation. And in those first 33 to 40 slides, that should have given you a good grasp on what is defined as the new money, how the system works. And it's right from Congress, ladies and gentlemen. That's right out of the archivist. That's right out of the statutes at large, okay? It is not hyperbole. It's not conjecture. I didn't make it up. I didn't write it up. I didn't dream it up, ladies and gentlemen. I need you to comprehend how powerful what I'm sharing with you is and where it comes from. Because giving you the information without giving you the source is worthless. And having all this information without putting it into action is, again, worthless. Well, what I'm about to share with you tonight is, in fact, the master key to everything financial. Understanding and comprehending that everything is a trust. When you see the word mortgage, understand it's a trust. When you see the Constitution, know that it's a trust. Yes. Does it have two different jurisdictions? Absolutely. Is it twofold? Yes. Do they run concurrent, simultaneously? Yes, they do. If you've been with me for the last few nights, you understand that there's maritime admiralty jurisdiction with administrative law judges and administrative law clerks and ministerial administrators administering statutes, codes, city ordinances, rules, and regulations. Okay? Trying to get you to enter into a contract with them and fall into commercial dishonor. And the second you fall into commercial dishonor, they know they're going to make millions off of it. And then you have the private side, the exclusive jurisdiction of equity, which is what the Constitution speaks of. That's the Article 3, Court of Competent Jurisdiction and Court of Record. You can invoke that on your documentation. You're responsible for invoking it. You're responsible for enforcing the law. You have to be sure of yourself and steadfast and unwilling to waver. Stand with conviction, no matter what the threats are. No matter what the inherent danger you may succumb to is, you must stand with conviction. That's why there is no substitution for reading. You have to read. But for those of you that are challenged day to day with just keeping up with the average everyday normalcy of your lives and keeping up with the kids and the baseball games and the football games and the basketball games, I make these video audios for you guys. So you can listen to them on the fly. So you can continue to grow and educate others and prosper while you're engaged with your day-to-day obligations and duties to your family, your friends, and your communities. Henry R. Gibson, Suits and Chancery. All right, Henry R. Gibson was an illustrious chancellor. He had many accolades underneath his belt. When he finally met his demise, or was called home, the funeral procession was miles long. Miles. That's how important this man was. Okay? So this is Henry R. Gibson, Suits and Chancery, subsection 962, suretyship, subrogation, substitution, exoneration. If you've been with me for the last few days, you've heard me use these words. And for those of you that have not been with me, just go back on my Facebook wall and you can go back and you can review the videos over the last few days. And I'll make sure to post them all back up to the top of the page again to make it easy for you. If I was you, Facebook doesn't leave my videos up for very long before they take them down. Maybe they'll be up 30 days. Maybe they'll be up 90 days. Might even be 120 days if you're lucky. But it never fails. Facebook always removes my videos. Okay? So if you were intelligent about the situation, knowing what I just disclosed to you, it might behoove you to download them and save them offline. I don't know anybody else that's giving this information out like this. All right? And like I said, my mentors highly frown upon me giving it out in such a public forum. It's better suited private, because this is really a private operation here. Subsection 962, suits for exoneration of sureties. Remember how I told you in the prior videos, you have always been the surety for the United States. You are a preferred stockholder in the United States. I've explained to you time and time again what evidence you have and the fact that you're a holder in due course, an entitlement holder. You're the Sestakiwi of the Sestakavai Trust that was created. I've explained to you how the estate was created. I've explained to you why the estate has a Social Security account number. I've explained to you who issues the account number, the International Monetary Fund, the IMF, and I've explained to you why. Because your precious valued time, commodity, and future labor was pledged to the IMF so the United States could do international business. I've explained to you the history of Abraham Lincoln and why he went in to liberate or free the alleged slaves, when in all reality, they didn't free anybody. Okay? And it was under the Treaty of Ghent. Article 10, to be specific. I've told you how to enforce that in any and all courts. And I've told you why it's so important. The enforcement is in Article 6 of the Constitution, Section 1. All right? And I implore and encourage you all to go read that founding document. It is so important. And then, of course, you have Article 2, Article 3, and Article 4. Article 81, Article 82, and 83 underneath the Federalist Papers. And you need to go read that to comprehend the invocation of Article 6, Section 1, and the Treaty of Ghent, and the Organic Constitution, and the 7th Amendment. All right? You have a right to a trial by way of jury, not a jury trial. Jury trial is under military admiralty law, under the law of mercantile, law of merchant. All right? And you're not going to get a fair shake in there. It's all under Military War Powers Act. They're allowed to lie to you. They're allowed to deceive you. They're allowed to use and abuse you. All right? But you have some documentation in your possession that proves that you're indemnified. And full acquittal and discharge must be had. Okay? But you have to understand how to articulate it. So I encourage you guys to go back and rewatch those videos. Excuse me. And download them. And watch them time and time again and share them with your friends and your family until you understand them. It has taken me years and years of blood, sweat, and tears and hard work and reading documents until my eyes bled. Literally, they looked like they were bleeding until I finally started to comprehend what is going on. So I do these videos because there's power in numbers, even though a republic is an individual thing. You have the right to reform, abolish, and amend your form of government anytime you see fit. That means you have the ability to fire a servant at a moment's notice. If they are not serving you and at your service, they are fired. Fired. That's simple. That's simple. If their education isn't meeting or exceeding your expectation, maybe they're a 2.0 GPA and they really don't know what they're doing, fired. Bring me your supervisor. Bring me somebody above your head, because you don't know what the fuck you're doing. But in order to fire people, your servants, you need to understand the law yourself. You need to understand and comprehend your power. You need to understand their duty and their operation and how they're supposed to do their job. When I was younger, back about 10 years ago or so, I started reading the domestic mail manual and the international mail manual. And I became so fluent in the domestic mail manual and the international mail manual that the postal employees and the postal manager thought I was a undercover postal inspector general. You want to be so fluent in it when you're telling them about their duties and obligations. You know them so well that when you ask the question, you already have the answer. You already know the answer. The reason you're asking the question is to see if whether or not they're competent or not to be interacting with you, or if you need to speak above their head. People say, well, Derrick, you say don't use statutes, codes, city ordinances, rules, and regulations. There are times when you do use those. There are times when you use the language explicitly right from them, but you may not use the number. You may not use UCC 9-102. You may just use the language within it. And then let them argue against their own statute. Because you didn't quote the statute, we don't have to do that. We don't know that to be true. Oh, really? Well, let's look at what your statute says. Well, you quoted our statute. No, I didn't. I didn't quote your statute. I have an semblance of words here that may mirror your statute, may look the same, may be fucking verbatim, but I didn't quote your statute. See what I'm saying? Let them prove themselves to be less than honorable or less than fit for duty because they don't know their own manuals, their own procedures, their own rules and regulations. Let them incriminate themselves and show that they've been taking their income under false pretenses, which is theft by way of false promises. Notice how I didn't use fraud? So, I'm so leery about even sharing this. There's so many people that are going to go out here and they're going to fucking absolutely butcher this. And I may do more fucking harm than I do good with this. Before we get started, I'm going to stress it one more time. Before you use this information, you better fucking know it in and out. They are going to test you on it. They are going to lay traps. They are going to try and get you to come off of this position and argue some minor benign issue and waive the major issue. Mark my fucking words. If you don't know this by heart and know what you're doing, you're in for a world of fucking hurt. And I don't say that lightly. I don't want to see people losing their homes or the roof over their head or finding themselves in a situation where they got to go hire a lawyer because they started something their ass couldn't fucking finish. These people will fight you tooth and fucking nail even though you're 100% correct. And if you're not ready for it, they will prevail. They get paid to harass, badger, intimidate, threaten. They will go to the extent of putting 5 or 6 lawyers on you, constantly sending you documents. It's called death by 1,000 paper cuts. And they will try and get you to default by not being able to answer or respond quick enough to those documents where you acquiesce to certain things. But if you stick to this, if you understand this and know it to be true in your heart, there is no way that you can lose. No way. It's impossible. Unless you don't understand it in its entirety and you go and argue a minor issue instead of standing steadfast on the subject matter before you today. Everything in equity must be done in good faith with clean hands. Okay? We were talking about Title 1295A being moved to Title 50 4305B2. I told you that Title 1295A and Title 50 4305B2 are not law. I showed you where the law is. Statute at Large 40 Statute at Large 411 Section 7E is actually the law, the foundation for Title 1295A and Title 50 4305B2. What I like about Title 50 4305B2 is it mentions done in good faith. Everything that you do in your life must be with clean hands and done in good faith. You must state your intent. Now, I know what you're thinking. Well, I didn't have this information prior to running into your video, or I didn't know these things in the past. Is there something I can do? There is always something you can do because you are the author, which means you're the authority. You are the original source value issuer of all issue. Okay? That promissory note is actual cash value and an asset to you on the asset side of the ledger for the debits. It is a liability on the credit side of the ledger. Credits are liability. All right? And there's a difference between a general deposit and a special deposit, a general verdict and a special verdict. Entire good faith is required between debtor and creditor and sureties. I'm telling you, in every transaction, there are always 3 capacities afoot. There may be only 2 individuals or 2 corporations or entities, but there will always be 3 capacities. You are not the all caps name. The all caps name is always the debtor. You're the authorized representative for the debtor. And you also fill the role as surety. And your property that you pledge on a collateral security agreement is surety as well. But that property is an inanimate thing. It can't speak. It may be general tangible property, which means you can touch it, lick it, spit on it, kick it, whatever. But it can't speak for itself. Only you can do that. So the capacity of surety and debtor, you are able to communicate under those capacities. Ultimately, they are presumed and assumed to be the creditor, which we know is impossible. How do we know that to be impossible? The fact that any business registered under the Secretary of State's office, ladies and gentlemen, is in fact registering through a subsidiary corporation of the parent corporation known as the United States that is in fact insolvent and in Chapter 11 bankruptcy. And for all intents and purposes, near as I can tell, is in form of liquidation at this point. Because they can't reorganize anymore. They're in a state of liquidation. The United States is now at a point where it can't reorganize, even if it wanted to. And what I think it's in is in a period of liquidation. So, entire good faith is required between all of the parties and these capacities. Okay? So you got the creditor, which would be the financial institution. Under Proclamation 2039, that was only supposed to last 1 year. In 1934, they went ahead and prolonged perpetually Proclamation 2040, which is the same as Proclamation 2039, which means everything is a financial institution underneath the executive branch. Everything. Okay? On the public side, everything is a financial institution. They're all insolvent. They're all under Chapter 11 bankruptcy, but they call themselves the creditor. And this is important that you understand that you're actually the creditor, but when responding to them, let them be the creditor. It's a presumption and assumption in maritime admiralty law. You're going to turn around and fill the shoes of the creditor, which is your rightful capacity. So entire good faith is required between debtor and creditor and sureties. Remember, the goal here is exoneration. Exoneration would be much similar to Title 15, what is it? rescission of signature. It's Title 15, United States Code 1635. Rescission of signature. And this is what I'm talking about. If you don't know what you're doing, these lawyers, these attorneys, they're pretty crafty. And they're pretty slick with their words. Some of them are pretty fast. All right? And in one case that I lost, it was this year, a few months back. The reason that the gentleman lost, and I absolutely despise losing, by the way. It fucking pisses me off like you wouldn't fucking believe. I fucking absolutely cannot stand not prevailing. Especially because everything is written in our favor, ladies and gentlemen. I mean, there's nothing that makes me more fucking miserable than somebody calling me going, "Oh, judge ruled against me. I lost. It's over." First of all, it's never over. It's never over until you fucking quit. Don't ever fucking quit. When you stand on the right side of things, you have a duty never to back down and to never quit. There's always a fucking way. But what ended up happening is, he used Title 15, United States Code 1635, right of rescission. And the attorney stood up and said, "Well, Your Honor, he can't even use Title 15, 1635. This is a residence." Well, who the fuck gets to declare it a residence? See, but the guy didn't object. He didn't know how to respond. Okay? He wasn't reading for himself. He was just listening to what I said and regurgitating it. Maybe he committed what I said to memory and was able to regurgitate it. But the second that attorney stood up and said that and declared that his property was a residence, he should have immediately objected. On the grounds, one, the attorney doesn't have firsthand perfected knowledge of shit and is now testifying. And I want it stricken from the fucking record immediately. All right? Assume facts not in evidence, facts not agreed to, and requires damn legal determination. Number one. Number two, Trinsley versus Pagliaro. Right? There's no letter of appointment, delegation of authority, power of attorney, warrants of attorney, grant of authority, grant of assignment for that attorney to even speak on behalf of the other party. No facts and evidence supporting that. And I believe none exist. Shut them down. But because the gentleman didn't rebut and rebuke the assertion of the attorney, in maritime admiralty, under the law of mercantile law of merchant, the judge presumed and assumed that the attorney was correct and that it was a residence. And as a residence, it's commercial. It deals with agricultural, industrial, or commercial. And therefore, there is no right of rescission, or the right of rescission is very limited. But when you go and read Title 15, 1635, and you make sure that your intent is perfectly clear and stated, that this is private household consumer goods, primarily used for household purposes and no other purposes are authorized. You see, that gentleman was the only one in the room who could have verified under the pains and penalties of perjury as to his intent. But instead, when the attorney said, "Well, this is a residence," he didn't assert himself and object. That's the danger in teaching people this stuff. So I don't want you to run out after I explain this to you guys and go, "Oh, I heard it here," and the guy speaks with conviction. He's very intelligent. Everybody rants and raves and praises him for what he teaches. And a week later, here's some crying, sad sob fucking story about, "Oh, I did what he did. It didn't work." Because you weren't with conviction and you didn't understand it. You need to be with conviction when executing this. You need to comprehend how it works. When you're asked questions, you need to be able to respond on the fly. You need to be prepared for the little tricks and traps they're going to lay to test you, to see if you're with conviction. They might test you 3, 4, 5. I've seen a judge test somebody 7 times, ask the same question 7 times in a different way, 7 different times, to see if he could get the man to argue some minor issue and waive the major issue. He stood his ground. He stood steadfast. He said, "I said what I said, and it's in writing. If there's any other question about that, I don't know how much more clear I could be." And finally, the judge ruled in his favor, and the case was closed. That was the end of it. Of course, there was always a right to an appeal, but that was never taken. It wasn't made timely for the plaintiff. So the defendant prevailed. And if a creditor does any act affecting the surety, I told you guys, you're always the surety. You always have that in your back pocket. That is always a capacity that you can put the hat on. Understand, you can't wear these capacities simultaneously. It's like wearing a cowboy hat and a baseball cap simultaneously. You look awfully fucking goofy. You have to understand there's a time to be surety and operate in that capacity, and then there's the time to turn around and operate in the capacity of the benefactor beneficiary, and then there's a time to be the grantor. There's a time possibly to wear the capacity as debtor, as the authorized agent, authorized representative. You go with agent, you may bear some liability. You go as authorized representative, you bear no liability, right? And it says the creditor does any act affecting the surety. How many of you know that you have the capacity of surety in your back pocket? Or how many of you knew of that before today? All right, full disclosure was never had with you at the car dealership, at the bank, with the credit card companies, with the utility companies. They never told you the nature and cause of the fucking transaction. They failed to disclose material facts. All right? Or if he omits, what is an omission? Failure to disclose a material fact. Ladies and gentlemen, that is a denial of due process of law. Omitting material facts to get somebody to enter into an agreement with you is a denial of due process of law. It's a form of inducement. Or he omits to do any act of duty which he is required to do by the surety. Now, if you were paying attention to the other videos, I was showing you statutorily where they're talking about everything that we're showing you here. This is the exclusive jurisdiction of equity, by the way. This is something that happens in private notice. This isn't something you're going to supplant into a court case. You're not going to grab this section and put it into a public venue. That's a huge no-no. Don't do it. Or otherwise bound to do. So in other words, the surety. Hi, this is Derrick, directly communicating to you as surety. And I am demanding and compelling and commanding of you certain tasks, certain duties of performance. To who? To the debtor? No. What does it say? The surety communicates with the creditor. The surety's principal is what? The creditor or the would-be creditor. See, they're taking your position here. They're switching you out. They become the accounts receivable. You become the accounts payable, but you're the one that funded the whole fucking operation. Because you're what? The creditor. Or otherwise bound to do, and that act or omission may prove injurious to the surety. This word right here is important. May. Which means it doesn't have to be injurious at that moment in time in particular. It could be sometime in the future that it becomes injurious to the surety. All right? So you could bring an action because it may at some point prove injurious to the surety. And therefore you have an obligation to make sure that it doesn't happen. Preventative maintenance. We don't change the oil in the motor of the automobile after the engine's blown because you look awfully fucking goofy. What's old Can't Get Right doing out there? Oh, he's changing his oil. Well, didn't he just come in saying he blew the fucking motor? What the hell's he doing changing the oil? Oh, I have no idea. Anybody gonna stop him? Fuck no. You can't fix stupid. You can beat the shit out of it, but you can't fix it. So what else do? You just look at it and you laugh. Call that entertainment for poor people. Right? Going and buying a spare tire after you get a flat tire on the side of the road is kind of pointless, isn't it? I mean, you got to go to town anyway. Why don't you just go ahead and fix your tire and then buy a spare tire to stick in your trunk. Come to town, buy a spare tire, go back out, put the spare tire, change the flat tire, put the flat tire back in your vehicle, and then drive back to town, and then get a new tire, put on your original rim and put it back on? Or would you just go ahead and take your damn tire off, get it into town, put a new tire on, then get back to town and buy you a spare tire? We do things practically. Practical application. All right? May prove injurious to the surety. Remember, the surety first has to give directives to the principal to do something or to bring forward something. And we're going to get into what that something is. And I'm explaining this extraordinarily slow, multifaceted, because there are a plethora of people out there that follow along. I think my last video had over 5,000 views. The one before that had over 10,000 views. And I know that not everybody learns the same way. So I'm going to explain it a multitude of different ways so people can grasp what I'm trying to say. It's in black and white. It's really simple, actually. But many people can't read this and comprehend it. Or if a creditor enters into any stipulation with the debtor, unknown to the surety, and inconsistent with the terms. What are terms? Terms and conditions create what? Contract of the original contract. The surety may set up such act, omission, or stipulation as a defense to any suit brought against him in a court of law or equity. This is maritime admiralty jurisdiction right here. Court of law and equity. This is under the Judicature Act. All right, this is where they commingled the law and equity, where they blurred the lines on the public side under Military War Powers Act. All right, because they didn't just do it in 1785. There was another Judicature Act after that, after 1871 as well. And so they blurred the lines because the public side is very envious of the private side. And on the private side, you have equity. And so they blurred the lines. I told you and pointed out to you the statutory equity in, 45 CFR, in between sections 28 and 53, okay, where it talks about the surety and validates everything that Gibson says. All right? What else is to grab here? Stipulation. I told you earlier that anybody in constructive possession of decedent estate property is liable for the transfer taxes on a carryover basis. They also have to have a delegation of authority, letter of appointment, grant of assignment, power of attorney from the Secretary of Treasury of Puerto Rico. They have to have a Rule 2 opinion letter, all right, in order to even touch decedent estate property, be in constructive possession of it. So when the surety is demanding a full accounting, you can use Title 15 United States Code 44. Again, I don't use the actual code. I use the language from it. You can use UCC 9-210. Again, I don't use UCC 9-210. I use the language in it. If you watch the last couple of videos, would it be 3 or 4 back? I give you exactly what you're going to demand as surety from these people. Okay? This is not something you're doing out of spite or malice or ill will. You are duty bound to do this as surety. Duty bound. Which means this isn't malicious in its nature. There's no discontent or contempt in your heart. It's just business. So there's no need to act irrational. There's no need to yell, hoop, holler, scream, fuck you. The IRS only cares about stipulations. Okay? Just like the Maritime Admiralty venues only care about prima facie evidence. If it's unrebutted, it stands true, and they move forward. There's a presumption and assumption that everything the plaintiff says in Maritime Admiralty jurisdiction is true, correct, accurate, not misleading, and it's on the opposing party to dispute, rebut, or rebuke the alleged allegations. With the IRS, anybody in constructive possession of decedent estate property, if they are unwilling, after the surety tells them the creditor, to produce the accounting. If they're unwilling to, the surety, all right, can make an assessment on how much the creditor has of value of the estate in their constructive possession. And if they fail to show, the creditor fails to show their accounting, then the creditor stipulates to the surety's accounting of the situation. Okay? The surety may set up such act, omission, or stipulation as a defense to any suit brought against him in a court of law or equity, so that if a creditor stipulates with his debtor, okay, first of all, the creditor is under no obligation to press the debtor to pay its debts. Let me say it again. The creditor, okay, who's the principal for the surety, is under no obligation to press the debtor to pay its debts. Why? You got to understand why. Because the creditor doesn't care if the debtor pays its debts. Why? Because you're the surety. What is a surety? Surety is someone who covers the debts of another or stands in place of another in the event they default. So the creditor doesn't give two flying fucks if the debtor ever does a damn thing. So let me ask you this. Why are the creditors always calling the debtors? Why are the creditors always calling the debtors? Why are the creditors always calling saying, are you Derek? Okay, we just need some information real quick. Can you verify your address? Can you verify your date of birth? Can you verify the social security number? Why do the third-party debt collectors need that information from you? Well, first of all, they don't have that information, and that's one of the criteria for them being able to bring a claim. They have to validate it somehow. They don't have the original contract, okay? They bought an account, but they don't have any of the original documentation. They're not the holders in due course. They have no firsthand knowledge of anything. So the creditors reaching out, the third-party debt collectors reaching out, acting on behalf of the creditor, trying to get what? Name, address, date of birth, social security number. Once they get that information, the Maritime Admiralty Court will presume and assume they're the holder in due course. They have all the proper information for pressing a claim. But here's where they fucked up. They contact the debtor without the express consent of the surety. Are they operating in good faith? No. Remember, there's three capacities here. There's three parties. You got the debtor, the creditor, and sureties. Did they avail the surety that they were privately going to communicate with the debtor? This is where it gets confusing because you're like, wait a minute, I am the surety and the debtor, so technically, you know, both capacities are there. No, because you can only wear one hat at a time. Okay? And they're trying to get information from the debtor. The debtor says, hey, I've come into hard times. Remember, you're the mouthpiece for the debtor. This is all fictional. You're the mouthpiece for the debtor. I've come into hard times. Here in a couple of weeks to get a nice check. I can make a little down payment here. Can you give me an extension of time of 3 to 4 weeks, you know, to get on my feet and get this paid? I'll get it caught up. What did the creditor just do? Creditor just engaged with the debtor, unbeknownst to the surety, and made a new deal. May that prove injurious to the surety? It might, sometime in the near future. Why? Because if the debtor isn't paying his debts, who has to cover the bill? The surety does. Right? So that if the creditor stipulates with his debtor in a binding manner upon a sufficient consideration to give further time for payment without the consent of the surety, the latter, the surety, will be thereby discharged. Okay? Discharged is the same as Title 15, United States Code 1635, right of rescission. Failure to disclose or omit material facts is a denial of due process of law. Using vague and ambiguous language and not creating the contract under the plain language doctrine is a violation and a denial of due process of law, which leads to the right of rescission. People think that they're rescinding the note. You're not rescinding the note. the promissory note, the letter of credit. What are you rescinding? See, because if you don't know this answer, you're going to flounder. You say, I rescinded the note. And the judge is going to go, okay, noted. And you're never going to comprehend why they said noted and just keep moving on. Because the rescission has nothing, fuck all to do with the damn note. And has everything to do with the collateral security. What did you use as surety? Remember, it's a general tangible. It's either the house, the boat, the plane, the train, the car, the automobile, whatever it was that you pledged as collateral is a surety. And so the rescission is on the collateral security agreement. Upon the rescission of the collateral security agreement, the collateral goes back to who? The surety. Let me put it to you this way. How do you pledge something you don't own without committing a crime? How can you pledge something you don't own without committing a crime of theft? Okay? You can't. You can't. So to prove that you own the house, the car, the automobile, before you ever left the building, if you took the time to read the collateral security agreement, it says, you agree to pledge the automobile as collateral security. Wait a minute. I thought you got a loan to get that automobile. How you pledging something you don't fucking own as collateral security? Why would you have to pledge something you don't own as collateral security? Help it make sense. I'm just trying to help you guys out. I'll try to help you see the bigger picture here. You're being hoodwinked. And again, it's not their fault. Whose fault is it? Whose fault is it? That's right, yours. Accountability, liability, responsibility is what this is all about. It's your fault. But the second you realize you're the fucking problem, what else are you? You're also the solution. Mama said there'd be days like this. It's going to get brighter, I promise. Days will get better. Conquering and comprehending this knowledge and this information and technology that I'm sharing with you will lead to better days. The latter surety will be thereby discharged. If the arrangement might be injurious, there's that word again, might. Might. Doesn't have to be injurious necessarily at that moment in time, but might be injurious sometime in the future. I'm telling you now, it's already injurious. It's just whether or not you can explain how it's injurious. Might be injurious to him. Mere delay on the part of the creditor, at least if some other equity does not intervene. Unaccompanied, in the negative. Why in the negative? Because equity always operates in the negative. I pay very acute attention to detail in courtrooms when I listen to these people, the bench pounders, speaking from the bench, because so often they give you the remedy in the negative. With any valid contract for such delay will not, in the negative, amount to latches. What is latches? Time limitation bar, latches, okay? In commerce, you have 72 hours. You have the lemon law. You have the 72 hours to turn around and say, you know what, I made an impulse. I had a knee-jerk reaction. I saw something pretty and shiny, and I pulled the trigger on it, and here I am. Less than 72 hours later, I made a mistake, and I'm going to go ahead and cancel everything. Cancel the agreement I went into. I was emotional at the time. Know how much time passes without lawsuit. You are still the surety. Okay? So as to discharge the surety for the creditor is under no obligation to press the principal, in this case, principal debtor, for payment. Who's the principal debtor? Who carries the primary active degree of fault for that all caps name? That's the United States. Who created it? The state registrar, right? Where was it sent to? The Commissioner of Commerce, the Commissioner of Agriculture, the DTC, the DTCC, the United States. Okay? They carry the primary active degree of fault. You have to understand why. You have to be able to express that trust. Let's talk about how trusts are created for just a second. There are 4 ways that I'm privy to that create a trust. It can be implied. It can be expressed orally. It can be expressed in written form, and your actions can create a trust. Okay? Just like contract. The contract is the same way. It can be implied. It can be orally spoken into existence. It can be expressed in written form, or your actions can create a contract. Trust can form the same way. When somebody has received value from the grantor for a certain task, your over-the-counter security, to settle all accounts, discharge everything, if you will, and they haven't used it for the purpose the grantor intended it to be used, instead whisked it away on the private side, maybe because you gave it with a blank endorsement, and they've taken that value and they're going to claim it as abandoned after 3 years. And then they have the audacity to call you the debtor. First of all, it was already paid for, whatever you were acquiring. How do we know? You did a credit application, and what did they say? Congratulations, you're approved. That means congratulations, we've received an electronic fund transfer. Thank you. It's settled up. That's how they get you to pledge your property for a secondary conduit loan without ever explaining to you. They're offering you a service and a product that they created called a mortgage, where they don't want money from you. They want you to pledge the asset as collateral security because you own it already. They also got the promissory note, which is actual cash value, that they never told you their intent was to turn it into a security and negotiate it on the open secondary market, known as the stock exchange. They failed to disclose material facts. It's not good enough just to allege it. You have to be able to prove it. But there's a better way. Right here, what I'm showing you is a better way than having to go through the arduous process of getting all this information to support your claim as the plaintiff. Because remember, the one who makes the statement has the onus of probandi of proof. The onus of probandi falls on he who makes the claim. So for the creditor is under no obligation to press the principal debtor for payment. In other words, unless the surety has told the creditor to do a thing, the creditor isn't supposed to be communicating with the principal debtor. In fact, there is no obligation or incentive for the creditor to even press the debtor for even late payments. Why? Because the surety is going to guarantee that the creditor will be made whole. So does the creditor even give a shit about the debtor? Abso-fucking-lutely not. But they do it all the time. They break the law to give you a remedy. They'll break the law. One of my mentors used to tell me, Derrick, they're breaking the law to give you a remedy. You just can't see it. You haven't figured it out yet. They're literally breaking the law to give you a remedy. For the creditor is under no obligation to press the principal debtor for payment. However, sureties are not obliged to wait for their principal. Who's the principal of the surety? The principal of the surety is the principal creditor. And this is why I break this down like this, because people read this and it's written in such a way that it's hard to understand and define. Well, they say principle here, and they say principle here, and so they must be talking about the same thing. They are not talking about the same thing. This is principal debtor. This is principal creditor. This is the principal of the surety. Principal creditor is the principal creditor of the surety, and the creditor has a principal debtor. So if the surety, however, the sureties are not obliged to wait for their principal to bring suit. We don't have to wait for the creditor to bring suit against the debtor, but are entitled to come into a court of equity after a debt has been due and compel the debtor to exonerate them from their liability by paying the debt. Due process to treasurer of my birth county. Now, this is for something completely different, okay? This is for a whole different type of transaction. When we're talking about automobiles, boats, planes, trains, cars, credit cards, that's where this gets supplanted. Whatever organization you're dealing with, whatever financial institution. Remember, if they're registered with the Secretary of State's office, you have an interest in them because you are the preferred stockholder that backs and floats the United States. So anything registered with the Secretary of State's office, you're part owner in. If a surety requests the creditor to sue forthwith, stating that he will consider himself no longer bound as surety if the creditor fails to do so, he will be discharged by the creditor's failure so to sue. You use this language exactly as it is when communicating to the creditor. You literally grab it directly out of Henry R. Gibson, Suits and Chancery, subsection 962, and you literally grab this language and say, hey, I'm the surety, and I demand you as the creditor to sue forthright the debtor. And if you fail to sue the debtor forthright within 21 days, I will no longer stand as surety. Got to have the caveat in there for it to have teeth. You got to state your intent. If his principal was solvent when the notice was given, but becomes insolvent after the expiration of the time probably required to prosecute the suit to judgment, if it had been promptly instituted as requested. Now let me tell you why the alleged creditor isn't going to sue the debtor. Who's the debtor again? It's the United States. The United States Treasury. When you read Title 31 CFR, the Treasury tells you that they're indemnified because they always fulfill their fiduciary obligation to extend the credits on account when you submit your application. They never are derelict in their duty. And they're very boastful about it. So do you think that the alleged creditor is going to go sue the Treasury and say, hey, we never received those credits? No way in hell are they going to do that. No way. You think they're going to go try and sue the United States? Not a chance. Not a chance. Because now they're going to get hemmed up with the IRS because the Treasury is going to say, oh, no. Here, this is exactly when the EFT was sent out for that credit application. This is exactly the time and date they received it. And they were in constructive possession of it. See why it's so important to understand suretyship and the capacity of surety? And this is all done in writing, ladies and gentlemen. You're not going to call them on the phone as surety. You're going to do it in writing. So you have the evidence, the proof. You're going to send it certified mail. So, this is about exoneration, right? And now you need to understand the elements of exoneration. This says there's 6, there's really 7, because you have to understand how to construct the document. Elements to exoneration, subsection 963, frame and form of bill for exoneration of sureties. This is the number one element right here. Bill for exoneration of sureties is the header of your document. This is element number one. The first element is always the top of your document must state what it's for, the intent, what the structure's all about. This is a bill for exoneration of sureties. Anybody reading the top of the instrument already knows, okay, now we know what we're getting into. Now we know what elements need to be there. Anybody that's learned sees the bill for exoneration is immediately going to start looking for the following 6 artifacts within the instrument. So the most important element is the top of your document. And this is going to be a bill for exoneration of sureties. The bill must allege, all right? Number 1, the fact of suretyship and how arising. You have to explain how you fill the role and capacity of surety. I signed the paperwork. I am not the debtor, name holder. Okay? The debtor is the all caps ens legis entity. Okay? And you, as surety, are backing the United States. What's that all caps ens legis entity again? That's right. It's the United States. It belongs to the United States. It's their problem. But remember, the public debt can never be challenged, right? And we know that extension of credit came immediately because that's their duty and obligation to us with the abrogation of the gold clause and the new money they created. By taking the gold and the actual dollar out of circulation, all we have left is promises to pay something sometime in the future, which the United States guaranteed us with full faith and credit that anything we should ever need or want, we can go get, because they created this new internal elastic currency that they call money that is then lent to the banks. The banks then take the notes, drafts, bills of exchange, bankers' acceptance, trade acceptances, along to the credit application with the receipt, which is a security obligation of the United States to the comptroller of the currency. The comptroller of the currency reviews it and then sends it over to the Treasury to produce Federal Reserve notes for bank-to-bank transfers and for no other purposes are authorized. That's the 73rd Congress, First Session, Volume 77, Part 1. That's what they agreed to. That's what they did to provide the people with a remedy. So the pretend creditor is saying that the debtor, the United States Treasury, didn't pay its debt. And is turning around and saying you, as surety, are going to have to cover the United States. And they want a specific form or specie. Well, the alleged creditor is barred from demanding a specific specie. It goes against public policy. Public Law 7310. It violates public policy. They can't demand a specific form of specie. Not species, specie. Because the only way a debt can be tendered in the United States of America, and furthermore the United States and the several states and the Union of States, is only one way: by the tender of gold or silver coin minted by the United States Mint, period. Acts don't abolish the Constitution, ladies and gentlemen. After the Reorganization Act, they created another entity. But that doesn't mean your republic is dead. It's still very much alive and well. Okay? So the fact that you're the surety and suretyship has arisen because you're just guaranteeing that the United States will pay its debts. The all caps ens legis entity. So it's by Derrick Gonzales for Derrick Gonzales, all caps, Social Security number at the end. I'm just the authorized representative. I'm not the agent. If you sign as agent, You're liable. Authorized representative, no liability. Agent, liable. All right? Above your signature, you can put without recourse. Void where prohibited by law. But it's by you as the agent, as the authorized representative for the all caps ens legis entity. 2, the solvency of the principal debtor when the right of action on the obligation occurred. It is unknown if at the time that entity was solvent. But what did you extend? A promissory note, right? You got the promissory note, the credit application, and the warehouse receipt that proves that you have special drawing rights. That proves that it's a security obligation of the United States. What else are you going to state on the instrument? You're going to let them know that it's for private household consumer goods and no other purposes are authorized. It's for private household consumer goods and no other purposes are authorized. See, because when you go in and sign all that documentation, guess what? Especially on cars, it starts out as an automobile at the top, and by the time you get to the bottom of the documentation, all of a sudden, magically, it's a motor vehicle. And 14 or 18 or 22 inches of paper, you start out as a buyer, and by the time you're down at the very bottom of it, you're a fucking debtor. If you've ever read the contracts, I mean, it blows my mind how people just blindly sign this shit. These are legal documents that have legal consequences. And ignorance of the law will not excuse you, for all men are responsible for knowing the terms and conditions, the contracts they enter into, and the conditions that it puts upon them. That's why you don't see any leniency. The solvency of the principal debtor, okay? We know that there was solvency on the principal debtor. Why? Because they said, congratulations, you're approved. So we know the principal debtor was solvent. We have the approval recognition, right? For you women out there, you're going to be really good at this. Because dictation is kind of your fucking forte. For men, we're fucking horrible about dictation. It's a real discipline and an art. You ladies have mastered it. I attribute it to the way the Heavenly Father wired you guys. You are really good at fucking dictation and archaeology. You could dig up the fucking past like nobody's fucking business. Piss a woman off, 10 years later, she'll dig that shit up, I fucking promise you. So, if you got a good woman in your life, have her sit down and watch this and understand it, because she's going to be your best fucking sidekick in this deal. 3, the third element. That after such right occurred, and while the principal was solvent, complainant notified, the surety notified the principal creditor to bring suit at once on said obligation, or he or she, the surety, otherwise identified as the complainant, would no longer stand as surety. Due equity, give notice to creditor to demand he/she bring suit, or he or she will no longer stand as surety. This is the same thing as Title 15, 1635. It's just being presented in a different manner, and hopefully presented to you in a way that you will understand it. You're coming forward on paper as surety for account number, whatever the account number is, and demanding that they bring suit against the principal debtor immediately. All right? And you're telling them in the caveat that their failure to do so, you will no longer stand as surety. What does that do? It obliterates, it decimates the collateral security agreement. And remember, who's the asset belong to? The surety that was pledged for collateral security. That asset that was pledged as collateral security, who's it belong to? The surety. So as soon as they're derelict in their duty, you and your property go free. They have to remove any lien or encumbrances and clean the title. 4, that after such notice, the creditor failed to sue in a reasonable time. If you tell them to bring suit in 21 days and they fail to do so, on the 24th day, you can send them the next notice that you're no longer standing as surety, and you demand that they remove all liens and encumbrances from your property. You're no longer part of this shit show. All right? Statement of interest and notice of failure. Okay? You got to do this with certificates of service and certificates of non-response. Highly recommend cultivating a notary to execute this for you. A disinterested third party who can testify to the veracity of the fact that the creditor did not respond timely. That in the interim between such notices and the bringing of suit by said creditor against complainant on said obligation, the principal debtor became insolvent. Okay, we know they were solvent at one point because why? Congratulations, you've been approved. Now all of a sudden, we don't know that they're solvent anymore because why? The creditor did not fulfill their obligation as ordered and demanded by the surety. This would be for the contract. 6, a prayer for relief. When you're doing a bill in equity, when you're doing your bill right here for exoneration of sureties, the end must always end with a prayer because we're in equity. All right. Equity sees that what should be done shall be done. Equity shows forgiveness, mercy, grace, love. All right. Prayer that said creditor suit be enjoined and complainant surety discharged from liability on said obligation. All right. That's if they're already bringing the claim. If they're already bringing the claim, you're going to join them as the creditors. The surety is going to come in on with the creditor and join suit and demand to be discharged from any liability. And as surety, you're going to remove your property as well, because it's the surety that pledged the collateral on the collateral security for a secondary conduit loan, which is really a service or product that the financial institution provides. It's a secondary transaction. They never informed you of that. Failure to disclose. This is normally the point I'd ask people if they had any questions, but being that it's just a audio video of me explaining this, that is suits for exoneration, coming in as surety, in the capacity of surety, understanding that the creditor is under no obligation to compel the debtor to do a damn thing, and if the creditor does make contact with the debtor, all right, without the express written consent of the surety, they operated in bad faith, not good faith. Okay? At the end of the day, the debt and credit are yours. The entire thing couldn't possibly happen without you because you are, in the beginning, the grantor. But I don't want to confuse anybody. Suits for subrogation, subsection 964. For those of you just joining us, this is Henry R. Gibson Suits and Chancery. One of the most important sections throughout the whole damn fucking book. And my mentors are heavily against me showing you guys this stuff. Do not just run out and do this because you think you fucking know how it works. Study it. Show yourself approved. And believe me, if you don't study it and you go in and try and execute this shit and they challenge you and you're not able to show yourself approved, you're not going to like the fucking results. Suits for subrogation, subsection 964. Suit for subrogation and substitution. This is the big one right here. Subrogation is the substitution of one person in place of a creditor. Right? As surety, you can use your exemption and turn around and fall right in to the position of creditor. Yeah, I'm the surety. Go ahead and use my exemption for post-settlement and closure. of this account. Thank you very much. Zero balance it. Let me know when it's done. Remove all liens and encumbrances on the property that's been pledged as collateral security. Let me know when you're finished. Thank you. Right? And then come in the role of creditor and be entitled to all rights, titles, and interests to the securities generated. Because remember, that over-the-counter security that you gave to them, that you didn't put special deposit on, that you made a general deposit with, they converted into a security. It's out there on the stock market being traded day in and day out with dividends and derivatives, rents, profits, proceeds, futures, and annuities attached to it that all belong to you anyway. They failed to disclose that's what they were going to do with it. They put paid to the order on and they converted and perverted the intent of the grantor of the instrument without disclosing it to you. That's omitting a material fact to your detriment and their gain. And they're supposed to be your securities intermediaries, your trustees, whose debt he has paid under compulsion, not being liable primarily, therefore, and to whose rights as to the collection of that debt he thereupon succeeds. That's the merger. Under the doctrine of merger, when you're merging legal title and equitable title, you become the grantee absolute. A full accounting has to be done. The taxes have to be paid. The trustee and the beneficiary agree on the amount of taxes due and owing, and then the disbursement of the disputed ownership funds occurs. So whenever a surety or other person secondarily liable discharges a debt, he, the surety, is entitled to the benefit of the collaterals or liens which the creditor held as security. That's the merger of the liens. And the person secondarily liable is entitled to be subrogated to the rights of the creditor against the person primarily liable. Who carries the primary active degree of fault? The United States for all debts, so long as you're not engaged in agricultural, commercial, or industrial purposes. You have to state it and clarify it on your instruments. This is for private household consumer goods, and no other purposes are authorized. This is not for commercial, industrial, or agricultural purposes. This transaction is strictly for private household consumer goods and no other purposes are authorized. Did you just state your intent on your documentation? Yes. Now the United States has a duty and obligation to you. They don't have an obligation to help you float corporations, agricultural business, commercial business, or industrial business. They do owe you an obligation because they took the private people's gold, the abrogation of the gold clause, the private people's side of the ledger. They took the actual substance and intrinsic value out of the economy that was guaranteed in the organic constitution, and now they owe you a duty only on the private side. They don't owe you a duty on the public side. They don't owe you a duty to discharge public debt as far as your private commercial businesses and retail businesses and residents that you're renting out and things of that nature. If it's for industrial, agricultural, commercial purposes, okay, then you have to pay the taxes. Then you have to pay that back. Because that's a financial institution you're doing business with. And remember, that's what the Federal Reserve notes are for. Bank-to-bank transfers and for paying taxes. And for no other purposes are authorized. But on the private side, for private household consumer goods, there is no tax liability. You're tax exempt. State your fucking intent. And again, even if you're doing this months down the road, let's say you already entered into a contract, but you don't feel like you really stated your intent very clearly, and you go back and you read that contract and you see at the beginning you were buying a boat, a house, and by the end it was called a residence. And residence, ladies and gentlemen, is commercial. They started you out on the private side at the top of the contract, and by the time you got to the bottom, it turned into a commercial venture. Words have power and they have fucking meaning. Go read your contracts. You will see what I'm talking about. The United States carries the primary active degree of fault for that all caps entity. They created it. You have the beneficial use of it. Okay, you're the benefactor. You're the heir. You're the holder in due course. The cesta QE having cesta K use of it. In such cases, equity regards the payment by the surety or other person secondarily liable as equivalent to a purchaser of the creditor's rights. Equity and collaterals as against the debtor's primary liability or liable. And the court will treat such payer as an assignee of the creditor to that extent. So a creditor is entitled to the benefit of any indemnity, see subsection 685, or collateral security given by the debtor to his surety, where in any case one not primarily liable pays a debt or discharges an encumbrance or lien being under legal compulsion to do so, he will, in equity, be substituted to all of the creditor's rights against the person primarily liable. You can do this in court. Go ahead and use my exemption for post-settlement and closure of this account. I just told you under Proclamation 2039 and Proclamation 2040 in 1934, it's been put into perpetual motion that all these entities are financial institutions. You have an exemption. Use it. Correct the record with the alleged creditor and let them know what your intent was and the nature and cause of the transaction. Notice how he never says that the surety must sue the debtor. In this illustration, the surety doesn't have to sue the debtor. In exoneration, the surety can bring claim against the debtor, but it's not necessary. It's an option. But in subrogation, the surety never has to sue the debtor. You are always the surety. You have always been the surety. You have to state that on the record. How do you state that on the record? Your private administrative process. All right? Must sue the debtor. It's never ever put that way. Rather, it's saying that you take over for the creditor, and that's that. It's merger and extinguishment of the debt, lien, encumbrance, poof, gone. Just that simple. The following are the most usual cases of substitution and subrogation. 1, where a surety discharges the debt or obligation of his principal. Okay, as surety, you discharge the debt. Through what? Your exemption. Every payment you ever made in life was as surety. Surety for who? The United States. The United States is the debtor principal. Not the principal debtor. Let that sink in. You've never been the principal debtor. Ever. You've never been a debtor. Ever. Sorry that they're muting it out on your side. A lot of people say that. Facebook, like I said, this video may not stay up very long. Facebook has a tendency of taking my videos down. If you're fortunate enough to see it, I would download it afterwards and store it offline. It will help you in the future. 2, where a co-surety pays a judgment. Co-surety pays a judgment. Remember when I told you earlier that when the surety pledges the asset as collateral security, that's the primary surety. That's the primary for liquidation. So the alleged creditor can be made whole. It's the asset that's the primary surety. You're the co-surety in this. But not to confuse people, I just say surety in general. The surety pledged collateral asset, and compelled the creditor to sue the debtor, and the creditor did not sue the debtor timely, and therefore the surety and his asset are no longer going to be pledged as collateral security or be surety because the creditor has failed to do its job. And the creditor has done something or omitted from doing something that is or may be injurious to the surety. Therefore, I'm out. The creditor is operating in bad faith. I'm gone. 3, where anyone not primarily liable pays the debt or discharges the obligation of the one primarily liable. Ladies and gentlemen, with your birth certificate, you can prove you're the power of attorney, you have special drawing rights, you hold the warehouse receipt in your constructive possession, and you are with the authority for full acquittance and discharge to use your exemption, to pledge your exemption for post-settlement and closure of all accounts. And you can put it in writing, and they have to do it. Because that is backed by the full faith and credit of the United States. And the United States Treasury did issue the credits upon your demand, which was made with your credit application. We have been paying the debts of the all caps. The all caps is the United States since 15 days after our birth. Time to subrogate or exonerate and seek restitution. Remember, when you exonerate or subrogate, you come into the role of the creditor and you're due a full accounting. If you go back to the other videos, you'll see how to demand that full accounting for those securities that were generated, those bonds. Where a purchaser, for his own protection, discharges an encumbrance on the purchased property due to threat that they take your house, car, money, children, liability, turn off your lights, turn off your cell phone, etc., you pay the debt for the principal debtor. You have a right to come in and claim the rights of the creditor and fill the shoes of the creditor and demand all rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel security, trust residuals, trust residue, rents, profits, proceeds, futures, and annuities. You'll have to slow it down in the video to catch all that. I may say it again. 5, where a junior encumbrance for like reason pays off a prior encumbrance, merger, and extinguishment. 6, where a person advances money to discharge an encumbrance on an agreement that he should succeed to the rights of the encumbrancer. Okay? That over-the-counter security promissory note you gave, that they whisked away and put on the private side, that's actual cash value. Yeah, ladies and gentlemen, that belongs to you. That belongs to you. And you're going to tell them to use that fucking tender to settle that fucking account. And if they don't, to send it back to you, that tender. And when they can't send that tender back to you, you're going to demand the actual face value, dollar for dollar, of that promissory note. If it's not in their constructive possession, then you want the full face value for it. Because if you go back to my other video talking about the 73rd Congress First Session, Volume 77, Part 1, it's 1,176 pages. We get down into the pages in the 700s, and it tells you that it's immediately to be discharged, dollar for dollar. It's not allowed to be reissued. If it's for private household consumer goods on special deposit, it is not allowed to be used to create Federal Reserve notes into the economy. It's immediately supposed to be discharged, set off, zero balanced. 7, where a devicee, heir, or legatee satisfies a debt against the estate for which others are equally liable. This is us. The debtor is a decedent's legal estate. The debtor is the decedent's legal estate. The debtor is the United States. We are the heir, and we are paying the decedent's debts at all time. The state is the estate's administration. This is all under maritime admiralty. This is all under trust law, ladies and gentlemen. Dragging this into the exclusive jurisdiction of equity on the private side. Remember, when you're executing this at the lower level, nobody's going to know what you're talking about. Under the doctrine of office found, if they don't send it up the chain of command, whoever your information landed on carries a primary active degree of fault for dereliction of duty. If they don't know what's going on, they need to send it up the chain of command. If they didn't send it up the chain of command, they now carry the primary active degree of fault. Eight, where any person, for his own protection or the protection of some interest he represents, pays a debt for which another is primarily liable. That's compulsion. Whether you signed or not, you are dragged into this suretyship because otherwise they will take your property, money, cut off your lights, etc. Okay? 9. When an insurance company pays in full a loss, it thereby becomes subrogated to the rights of the insured against the party causing the loss and against other insurers. 2016 SCOTUS Montanil case already looked at. Subsection 965. Form of bill for subrogation and substitution. More elements. Okay? So this is going to be a bill for subrogation and substitution. That's the first element. It needs to be at the top of the damn document. This is a bill for subrogation and substitution. We're subrogating for the debtor, and we're going to substitute and place ourselves in the role of the creditor. The plaintiff, surety, it's going to be you, as surety, conferred a benefit upon a defendant creditor by paying the debtor's debt. How do we pay the debtor's debt? The over-the-counter security and promissory note. Okay? Or we extended our exemption for post-settlement and closure of the account. Those accounts belong to you, by the way. They're not the bank's accounts, they're your accounts. They wouldn't have those accounts if you hadn't first provided them the particular information they needed to open those accounts. 2, the defendant had knowledge of such benefit from notice and under circumstances where it would be unjust for him to retain the benefit without payment. There's a court case on that, Beatty versus Guggenheim. Beatty versus Guggenheim. All right? They can't accept the benefits and pretend to be the beneficiary when they are the trustee. And I'll pull up the Beatty versus Guggenheim real quick. Right here. Beatty versus Guggenheim Exploration Co. It's a New York case, 1919, 225, New York 380. Is a New York state case, state precedent. You know, I don't like case law bullshit, but state law case concerning the test for the imposition of a constructive trust. It is best known for a quote from the leading opinion by Justice Cardozo. The constructive trust is the formula through which the conscience of equity finds expression. When property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts him into a trustee. Put that in your spank bank. That's a good one. Paying back the surety. All right? So the defendant had knowledge of such benefit. Who's the defendant? The creditor. Had such knowledge of the benefit from notice and under circumstances where it would be unjust for him to retain the benefit without payment. Paying back the surety. All right? They can't hang on to the title. They can't hang on to the liens. They can't hang on to the interest and dividends and derivatives they're going to gain from placing that over-the-counter security into the secondary stock market. All right? They don't get to unjustly enrich themselves from their own wrong. Okay? What they did was wrong. They failed to disclose a material fact. They did not tell you what they were doing. All right? It's unjust enrichment is what it's called. Exonerated. 1. Demand to the principal to pay the debtor or you will be discharged. Request to creditor to sue the BC or to sue the debtor or you will no longer be bound. Okay? Sue the debtor. Sue the United States Treasury. All right? Sue that all caps ens legis entity. Or you're no longer going to be surety and you're no longer going to pledge your property and risk losing it. All right? Number 5 says, when the BC is shown to be insolvent, okay, first of all, we know that the entity was solvent at one point because, congratulations, you're approved, right? So we know they were solvent at one point, okay? To be insolvent, then the surety is discharged. Example, I, the surety, under legal compulsion to do so, hereby having made all the payments for and on behalf of the principal debtor since the beginning, do notice all parties that I am subrogated to the rights of the creditor in this, all transactions, in this transaction. And this is for every transaction. Your over-the-counter security identified as a promissory note converted into an order to pay, which makes it bearer paper, which means anybody in constructive possession of it can demand payment, all right? That was an unlawful and illegal conversion and perversion of your intent. And now that it's out there floating on the secondary stock exchange, the secondary market known as the stock exchange, excuse me, you're entitled to all rights, titles, interests, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel security, trust residuals, trust residue, rents, profits, proceeds, futures, and annuities. All of it for the next 30 to 40 years. However long it's out there in the market. Example, I, the surety in this matter, for my own protection, do hereby make the payment to protect my private person property as the surety to the principal debtor, and furthermore give notice that I, as surety, am the subrogee, and that you, the bank creditor, are the subrogor. You are hereby noticed of my sole exclusive act to subrogate you to my rights as the surety. In other words, use my over-the-counter promissory note, over-the-counter security, to satisfy the account because it has actual cash value. Dollar for dollar face value. You're forcing them to acknowledge that your over-the-counter security is money. And is backed by the full faith and credit of the United States. Subsection 683 Gibson's, for by the original bill, where facts which have since occurred may require it, thus, if a surety while seeking indemnity against his principal has the debt to pay, he must by supplemental bill bring this fact before the court. It's not good enough just to tell the creditor, you have to bring it before the court. By pledge of property to secure the debt of another, where a person pledges or mortgages his own property to secure the debt of another, the property so pledged or mortgaged occupies the position of the first surety. It's right there. Can't miss it. Subsection 962 and 963, Gibson's exoneration of sureties. Suits for exoneration. 962, suits for exoneration of sureties, subsection 963, frame and form. They're telling you the frame and form must be a bill for exoneration of sureties. Subsection 962, suit for exoneration of sureties, entire good faith is required between debtor, creditor, and sureties. There it is again. Same explanation as before up above with suretyship and exoneration, right? And if a creditor does any act affecting the surety, or if he omits to do any act of duty which he is required to do by the surety or otherwise bound to do, and that act or omission may prove injurious to the surety. Did the creditor do anything, any act affecting you as surety? Sure they did. They omitted material facts. They failed to disclose, right? Did the creditor omit to do any act affecting you? Absolutely. Was the creditor required to do anything by the surety you? Did you put them on notice to sue the debtor? Did you appoint the creditor? Did you give them a letter of appointment, a grant of authority, a license, a delegation of appointment to do something? You have to be able to physically show that you did. That's why I'm saying do this on paper. I, Derrick, as surety, am now compelling you, the creditor, to sue the principal debtor. Did you deliver coin dollar to settle? Perfect title, root title, perfect title doesn't transfer without value and consideration. Did you demand discharge as surety to creditor? That's your caveat. If you don't do this, then I demand that you discharge me as surety and the property pledged in the collateral security agreement. Did you stipulate? Remember, the only thing the IRS gives a fuck about is stipulation. Okay? And the caveat, your failure to do so, you stipulate and agree to the following terms and conditions. Novation. Some people call it accord and satisfaction. I would say novation. The injury that would occur to you if the creditor did not apply the special deposit. Special deposit is your over-the-counter security, your promissory note. That's called your tender. There's a credit application, a tender, and a warehouse receipt that need to be aligned to each other to make it a security obligation of the United States. Or if a creditor enters into any stipulation with the debtor unknown to the surety and inconsistent with the terms of the original contract. Did the creditor or third-party intervener proclaiming to work on behalf of the original creditor contact the debtor and try and renegotiate terms and conditions? Otherwise known as a third-party debt collector. See, third-party debt collectors are still bound by the original contract. Third-party debt collectors are telling you that they're attempting to collect a debt on behalf of the alleged creditor. They're trying to make you the accommodation party. You're not the accommodating party. You're not the payer in this whole matter. The surety may set up such act, omission, or stipulation as a defense to any suit brought against him in a court of law or equity. You want to come into the equitable side of the venue. And that's why you're constructing your bills very carefully. And you're using directly from Henry R. Gibson's Suits and Chancery exactly the form, bill for exoneration of sureties. If you're saying you're bringing suit, you will fail. It must be a bill for exoneration of sureties, right? A bill for subrogation and substitution. It's different than a complaint. If you're filing a complaint, you fucked up. It's a bill. Words have power and they have meaning. You want to get in the right fucking jurisdiction? Use the right words. Did you know the power of the surety is to stipulate to the creditor? Did you serve your stipulations upon the creditor at closing or later or before the transaction? You can do it before the transaction, after the transaction, during closing, okay? You're the author, you're the source, you're the authority. You can state your intent at any time. It's best to do it in the beginning, right? But being that you didn't know this information back when you entered into that agreement, And now that you've come into this information and you're starting to understand this information, now you can adjust properly. Because it was always your intent to acquire private household consumer goods. And they were authorized to be used for no other purposes. Did you demand full disclosure of the contract the creditor has with the all caps name, social security card, or birth certificate? On that contract, they need name, date of birth, address, social security number. Those are the magic things that unlock Pandora's box for the Treasury to kick out either Federal Reserve notes or credits on account. Did you make a list of defenses of the stipulations you made to the creditor and the creditor did not do? All right. Do you have the physical evidence and proof? Did you have a disinterested third party send the correspondence and keep a certified copy of the correspondence that they mailed in the mail, having the disinterested third party be the non-biased individual set to receive the correspondence from the creditor or alleged creditor to the disinterested third party? So now you have a witness of the correspondence and the times and dates. Can't be the judge, jury, and executioner of your own claim. You need disinterested parties as witnesses to the actions taken. So that if a creditor stipulates with his debtor in a binding manner upon a sufficient consideration to give further time for payment, what happens? What happens if the creditor goes into a new terms and conditions with the debtor without notifying the surety? That's bad faith, right? They're not operating in good faith. They left the surety out of the conversation. The surety has what? Discharge. Without the consent of the surety. Hey, I'm the surety. I'm just getting a hold of you. You're the principal creditor here. Yeah, you know, I've been reached out by the debtor, and the debtor said you guys contacted him the other day and did an extension of time for him. Is that true? Did you guys really do that? Okay, well, at what point did you have my consent to do that as surety to reach out to the debtor and renegotiate the deal absent my consent and my knowledge? You operated in bad faith. I'm no longer going to be the surety now. Release a lien on my property immediately, or I'll file suit against you. You're in breach. You omitted a material fact. You breached the contract. You breached the agreement. You've put me in harm's way. And as a surety, I'm no longer going to be the surety. Release a lien on my property. All right? The latter will be thereby discharged if the arrangement might be injurious to him. Was there a sufficient consideration tendered to debtor without your knowledge? Did the creditor extend terms for payment that was not noticed to surety? Did they extend the terms and conditions and the time without notifying you? As surety, did they contact you first? Did your principal creditor contact you first to see if they could even contact the debtor? Okay. Can the creditor prove he has consent from the surety to deal with the debtor? So this is a scenario. Phone call. Hi, this is the Bank of America. Hi, bank, I'm the debtor. Yes. Okay, you're getting a call from the bank. Let's just say this is U.S. Bank. And they're calling you, and they're saying, hello, you know, you're late on your payments. Excuse me, are you Derek? Sure, I'm Derek. Okay, Derek, we just need to talk to you about this payment that you're late. Am I the debtor in this situation? Yes, you're the debtor. Okay, before we discuss anything directly, do you have the consent of the surety to even talk to me? Watch how fast that phone line goes dead. Because remember, they tell you, hey, we're recording this line for training purposes and other purposes. All right? You're going to fill the role of the debtor in the phone call conversation. You're going to be wearing that capacity. The surety is now discharged because you are talking to the debtor without the surety's consent. How can I know if our arrangement, our agreement, our contract be injurious to the surety? See, the debtor's being smart, and he doesn't want to get put in a position where he might be held accountable by the surety, and the surety might have suit against him. I know it gets a bit confusing because you're like, wait a minute here. I'm wearing multiple capacities, and I could be the debtor and the surety and the grantor, and I could be the original source value issuer of all issue, and I am the creditor. Yes, it's a bit confusing. That's why I said don't pull this fucking trigger till you understand this shit. Attorneys turn property from one and give to another using a false conveyance of language to enact an artifice or a scheme or a device to trick you out of your property, which you're rightfully entitled to, your rights, titles, and interests. Is the surety consenting to this arrangement? And you could be injuring the surety if I have more time to pay, right? This is just a scenario. Phone rings. Hey, this is Bank of America. Am I speaking with Derrick? Yes, this is Derrick. Am I the debtor in this situation? Yes, you're the debtor. Okay, great. I've fallen into hard times. Can I just get an extension for a couple of weeks? Got a paycheck coming in. I can send you a good faith payment and stuff, but can we extend the payment? Sure. As soon as I get off the phone, I'm immediately writing as the surety. Immediately corresponding with the alleged principal creditor as surety. Did you just contact the debtor and give them an extension of time? Oh, you're immediately removing me as surety. And you're going to remove my property as collateral security agreement backing the secondary conduit loan and agreement. You contacted the debtor without my express written consent, without my authorization, and renegotiated a deal. All right? You operated in bad faith. I'm done. I'm out. We're not business partners anymore. Mere delay on the part of the creditor, at least if some other equity does not intervene unaccompanied with any valid contract for such delay, will not amount to laches, so as to discharge the surety. I, the surety, stipulate and demand you sue the debtor by 30 days, or consider me and all my property discharged from this transaction as surety. For the creditor is under no obligation to press the principal for payment. Okay? Remember, the surety has a principal creditor, and the creditor has a principal debtor. But until the surety gives the orders to the principal creditor to sue the principal debtor, the principal creditor can't have any conversation with the principal debtor. All right? I, as surety, do stipulate that if the creditor does not apply the debtor's security, what's the debtor's security? That over-the-counter paper, that paper, that tender, that's the debtor's security. See, they wished that off on the private side. They took it as a general deposit and not a special deposit. They received it and accepted it as a gift, like a donation. It didn't have any qualifiers on it. You didn't tell them what to do with it. And don't worry, just because you didn't and they had it at one point and they're no longer in constructive possession of it, they still have a duty when you write to them and do an allonge to the instrument. Take a certified copy of the original note and do your allonge to it, telling them exactly what the fuck they're going to do with that over-the-counter security. You didn't gift that to them. You're going to let them know you're not the accommodating party. All right? You're not an accommodation party. You're not going to foot the bill for a secondary loan for some fucking product or service they provided secondarily. I as surety do stipulate that if the creditor does not apply the debtor's security as tender, remember, that promissory note is tender, 48, statute at large 112. Dollar for dollar of payment and collection, or state that you are disclaiming the tender. This is dangerous. If they disclaim the tender and can't give it back to you, they're in big trouble. All right? If they're not reporting this tender to the IRS and paying the taxes on it, they're in trouble. Or we're unable to get collection from an insolvent debtor to the account as paid in full, then I shall be discharged as surety. That's your caveat, or can be your caveat. However, Sureties are not obliged to wait for their principal creditor to bring suit against the debtor, but are entitled to come into a court of equity after a debt has become due and compel the debtor to exonerate them from their liability by paying the debt. This is what bankruptcy is: discharge of surety, because the debt still exists. When it's discharged, the debt still exists. All right? Post-settlement and closure, set off, whole different game. Has notice of a due debt been properly served upon the debtor and surety? You got to go back and read those contracts, because sometimes it says that you're waiving the right to have notice served upon you. All right? So go back and read it. Exoneration is release of surety by debtor. Compel the debtor to exonerate the surety. So, if you take the time and study this, and you study the last few videos I've done for free on Facebook, just go back to the videos, or the last couple days, and you'll finally understand what this is all about.